start off the presentation by talking about wills. A lot of people don't understand the difference between a will and a trust. So the main thing about a will is that it talks about the properties and how they're distributed after someone passes away. When a will is first drafted, no assets change title. The will is kept in a safe place, like a safety deposit box, until the person who created the will passes away. Then the assets are distributed. When a will is created, the properties still have to go to probate. Probate is the court that manages all the assets when a person passes. Sometimes probate can be very expensive, very time consuming. But if the person who passes has a will, then the judge just looks at the will and says, okay, all these assets are going to people A, B, and C. And it becomes a really simple and quick process. Later, we're going to talk about trust, and trusts are even better than wills because the trust can completely bypass the will process, the probate process. So what are some of the advantages of a will? Well, first thing is it provides easy property distribution. When the person dies, the family members and friends don't have to fight over the assets because everything is clearly specified in the will. It also reduces taxes, and we will later talk about the estate tax exemption and how estate planning can help you overcome that exemption. Additionally, it names fiduciaries, so you can designate someone to be the executor of the will. That is the person who helps you carry out the will, someone who you trust to follow all the terms of a will and distribute the assets to your loved ones. It also can allow you to designate individuals to take care of your children, designate guardians. So not just distribution of assets, but taking care of minor children or even incapacitated or disabled family members. If you have an adult, an elderly in your family that you want to make sure is provided for in case something happens to you, you can designate and specify that in a will also. So there's a lot of advantages for why making a will is beneficial. Here are some key terms that are commonly used when creating a will. So the official definition of a will is a declaration of how one wants property distributed after their death. And remember this after their death part, because I know I'm going to get the question again. What is the difference between will and a trust? The main thing is will is after someone's death. Trust is something that is carried out now when the person is still alive. The title can immediately change into the trustor's name, and it does not wait until after death. So remember that will happens after death. The testator is the person who creates the will, and the beneficiary is the person or an organization or a charity that is able to obtain the property when the testator passes away. So remember all of these key terms. Later, if I mention testator, you know what that means. Testator is the person who creates the will. Any questions so far?
So Elizabeth, if I have a trust, I am the testator, right?
Exactly. Yes. You're the testator if you create the will.
Very good. Thank you.
Yeah. Thank you for the question. There is a law called the Statute of Wills. And basically what that says is a will has to be in writing. A lot of times people think they think that verbal promises are enforceable. So let's say, your uncle passes away, and before he passed, he promised you that you will get all of his real estate. If that is not in writing, signed, notarized before witnesses, guess what? It's not enforceable, it's not effective. So if someone promises to give you any assets when they pass away, it has to be written down. The statute of wills says that not only does it have to be in writing, the testator also has to have capacity. So they cannot be sick on their deathbed, half, like on a lot of medication, can't really think for themselves and just scribble their name on a document. That's likely not going to hold up in court. So it's likely going to be set aside because of a lack of capacity. So you got to do the will when you are healthy and in the proper mental state. In this last year during the pandemic, a lot of people contacted me when their loved one is already in the hospital. And at that point, it's too late to create a will or a trust because, first of all, the testamentary capacity may come into question. Second of all, in California, 2 witnesses are required to sign with the testator in order for the will to be enforceable. During the pandemic, when someone goes in the hospital didn't allow any visitors. And so the notary can't go in to notarize the document, and neither can family members to serve as witnesses. So even if an attorney drafted a will, it could not be executed. So don't wait until it's too late, because when a loved one is already in the hospital and then you call the attorney, there's really not much we can do for you, or hands will be tied. Do it now when everyone is healthy and can execute it with proper capacity and have the appropriate witnesses. That's lesson learned. And a lot of people still don't listen to me. They wait until the last minute. But reminder to everyone to get it done earlier than later.
Good point. Yes. Thank you.
Yeah. And an additional point in regards to witnesses, try not to have the witnesses be beneficiaries on the will. So let's say you're leaving your property to your siblings. Don't have your siblings be the 2 witnesses that are witnessing your signature, because it's easy later on for other people who want your assets to say like, oh, he or she didn't really sign it. This is a forged document. And look, even the witnesses, they have an interest in the property, and that's why their signature is on there. So try to find third-party neutral witnesses. The notary can be one witness, and even the attorney can be another witness, but don't have the beneficiaries be witnesses in the will. And same with the trust as well. Well, don't have witnesses that may have an interest. It creates too much conflict. So what is undue influence? Undue influence is something that makes a will invalid, and it's used in court many, many times. It means that someone is exerting a force on the testator that controls and influences the testator to a point where they are doing something against their free will. So a lot of times, the testator's caretaker, whoever that person is, whether it's a family member or a paid caretaker, because the caretaker is spending so much time with that person, they can easily be speaking a lot of stuff into their ear and say, look, I'm always here taking care of you. Your children are not here. Your family members are not here. Here's a document. You should just sign it and give everything you have to me. And so that happens a lot. And because the person may be mentally, emotionally weak, they might just follow what that person says because their livelihood depends on that person. So if that happens, a lot of times those wills are also challenged in court, and undue influence will be the reason that's given to make that will unenforceable. So be careful of the image of undue influence. Even if you think there is no undue influence, the image, the perception of undue influence, if it goes before a judge and the judge thinks that there is that possibility, then it could be set aside. So that's definitely something to watch out for. Moving on to how to revoke a will, how to cancel a will. So there's lots of different ways. If you have a will drafted, it's not permanent in stone. You can always change it or revoke it. Physically revoking it is a way to cancel it. So you can burn it up, you can tear it, you can throw it away, destroy it. That's definitely a way. Some people come to me and they say, I had a will executed 10 years ago, and I am not the most organized person, so I have no idea where I put my will, but I definitely want to update it. What do I do? So we'll say, well, you don't have to know where your will is. We can help you draft a new will, and in the new will, it can specifically say that all prior wills are hereby revoked. So that is another way to revoke your previous wills without having to find it and tear it up and burn it. Right. So as long as the subsequent will revokes it, the courts look at the last executed will. They look at the last date, whichever one is the most recent will. That's the one that holds up in court. What does the term intestate succession mean? Intestate succession means if someone passes away without proper estate planning. So let's say a person dies and they have never gone to an attorney to get a will and trust done. Then that means they died intestate. And what happens is that there are no listed beneficiaries. So the property go in a particular order. Number one, if there are children, all of the assets go to the children. If there are no children, but the parents are living, then everything goes to the parents. If the parents are not living either, then it all goes to the siblings. And then if there are no siblings, then it goes to the grandparents. So that is the order. And if no family members can be found, no heirs, then what happens is all of the property goes to the government. That's what happens when there is no will. So that's why it's so important to have a will, because you can name specific beneficiaries. You can name friends. You can name distant family members. You can name charity organizations. A lot of folks are creating what's called a charitable remainder trust, where all the assets after their family gets it goes to a charity of their choice. It can be a church. It can be something they're passionate about. And on top of that, they get tax savings too. So lots of benefits for estate planning. Does anyone have any questions on wills before we get into trust? Okay, since there's no questions, we'll move on to the more interesting topic of trust. More people have an interest because trusts have so much more advantages. So the official definition of a trust is a fiduciary relationship with respect to property in which the trustee holds the property for the benefit of another person. So here, instead of having just the testator and the beneficiary, there's now 3 parties involved. There's this additional trustee that's involved. And here are all the terms. So earlier we said the testator is the person who created the will. In a trust, that terminology changes. Now it becomes the settlor or the trustor. That's the person who creates a trust. So if you create the trust and you own it, you are the trustor. The trustee is a person who you can designate to manage the trust for you. See, there's in the will, no one is managing the will because the will does not even come into effect until the testator passes away. But here in the trust, because the assets are moved into the trust while the trustor is alive, you got to have someone to manage it. A lot of times the trustee can be the same person as the trustor, but sometimes it can be a third party. It can be a family member or someone who the trustor believes will actually do the job of managing the trust. So you can also have a primary trustee yourself. And then if you're not able to manage the trust, then designate a secondary trustee to manage the trust as a backup. And then, of course, the beneficiary is the same as for a will. It's the people who receive the assets of the trust when the time comes. Here is a chart showing the relationship between all the parties to a trust. So in the green box, that is the settlor or the trustor, the creator of the trust. That person gives legal title to the trustee, not equitable title, legal title. And legal title means that the trustee has the legal power to manage the trust and move the assets per the terms of the trust. The trustee manages the trust for the beneficiaries, and the beneficiaries, because the property ultimately all goes to them, they hold equitable title to the trust. Okay, so the trustee and the beneficiary have different titles. One is legal, meaning they can only manage it, it doesn't belong to them. And one is equitable, meaning the title will eventually go to them. Any questions on all of these terms and relationships that make a trust work?
You have a very smart audience.
I do, yeah.
Yes. And you explain very clearly. So far, no question yet.
Okay, great. Well, we're going to get into the more complicated aspects. Okay. And I'm sure more questions will come up as we get deeper.
Right.
So here are the advantages for creating a trust. The first thing is that a trust will avoid probate. Remember earlier, we talked about how a will does not avoid probate. You still have to go through probate, but it makes the whole probate process a lot cheaper and faster because the will has everything laid out. But a trust, you don't even have to go to probate at all. No probate court case is ever opened. And the reason is because there is already a trustee that can manage everything. You know, let's say you have a house in the trust. The trustee has the power to sell the house, to write checks, sign checks, to pay for the expenses of the real estate, to pay property taxes, to manage the tenants if it's a rental property. So the trustee has the power to do everything already. And so you don't need to go get a judge involved. You can completely skip the probate process, and it really reduces costs and time. If there is a guardianship clause in the trust where you have someone who's taking care of a minor or a senior, you can also avoid going to court to discuss guardian proceedings. So that's also, saves a lot of time and money. Additionally, there is a privacy advantage that comes with trust, because if you put your asset into a trust and your trust has a unique name that is not your name or your family name, it won't come up in public searches. Let's say, you get into some kind of auto accident, a personal injury case, and you're afraid that the other person wants to sue you for the personal injury, and you have some houses under your name. Well, when the attorney representing the other side is deciding whether to take on the case or not, one of the first things they do is they search for assets under your name. if you have deep pockets and you have several real estates under your name, then they're going to come after you, because if they get a judgment, there's money to collect on. Well, if all your assets are in a trust and then they search your name in the public database and no assets come up under your name, that attorney on the other side is probably going to think twice before filing a lawsuit against you, because even if they get a judgment, you have no assets for them to collect against, at least not from what they can see on the initial search. So that gives you privacy by putting your assets in a trust. And you can avoid some lawsuits that way. You avoid publicizing the value of your assets. So a lot of folks who are wealthy and have a lot of assets in their name, they prefer to put everything in the trust name and not in their personal names. So that's a big privacy clause. And I know a lot of people like to name the trust using their family name. Like if if my last name is Yang, it would be Yang Family Trust. I highly discourage that. Don't use your name. Don't have any relationship so that people can associate the trust to you. Use some kind of neutral name, like I've heard about, Golden Dragon Trust, or Lucky Fortune Trust, something that is unique but does not connect strangers to you and the trust. That gives you that privacy advantage.
Good point. Good point.
Mm-hmm. Mm-hmm. Yeah. And other advantages is that if you become incapacitated, it's definitely much easier management. So, for example, during COVID, when people got sick and they would spend weeks in the hospital, during that time, if they have a lot of assets that require management, like let's say rental properties, their trustee, their secondary trustee or whoever their trustee is, can still manage their assets even when they're not available. So they can take a break and be able to have a peaceful time in the hospital without worrying about, oh my gosh, who's going to deposit my checks? Who's going to pay my bills that are coming up? So when they're unable to manage their real estate, the trustee can manage everything for them. They already have that power given to them ahead of time. So that's another big advantage of the trust. And of course, tax savings is a huge advantage. And we can talk about tax savings by discussing the different types of estate tax. These are taxes that are assessed when someone passes away. They're not, it's different from income tax. This is estate tax. So when someone passes, the federal estate tax in the United States is 40%. That's almost half of all your assets. That means if you have, $10 million, $4 million is going straight to the federal government. So 40% is a huge chunk. Mm-hmm. In many states, there are also, on top of the federal estate tax, a state estate tax, and on top of that, an inheritance tax. Fortunately, in California, we don't have state estate tax or inheritance tax, but you got to watch out because I know a lot of people have property outside of California. So if you have assets in a state that does have a state estate tax and an inheritance tax, if you don't have proper estate planning, more than half of your estate will be going to the government when you pass away. That's why a lot of people, they're thinking ahead for their beneficiaries, and they got to do their estate planning so their beneficiaries can actually get most of their earnings and everything they save for them, and it doesn't all go to the government. So the government also has the estate.
Can I ask a question?
Yeah, of course.
Okay, you talk about the estate tax and inheritance tax. It's a different thing, right?
The estate tax and the inheritance tax are different things. These are three types of different taxes that are implemented in the estate planning world.
So you mean the state with the estate tax can also have inheritance tax, have both. I know in California it's neither one.
Yeah.
But
So
some states do have everything.
some states do have everything. Yeah. I listed the 6 states that tax. So fortunately, in the whole United States, there are only 6 states that have the inheritance tax, and they are listed on the last line of the screen. But there's a lot more than 6 states that have the state estate tax.
Okay, I have 2 other questions regarding the will. I'll quickly say that the will, okay, needs to be probated. And how difficult is to probate a will?
It's not that difficult because as long as the will is clearly written and there aren't any objections, like there's no family member saying that, oh, this will has undue influence. It was signed when the testator was incapacitated. As long as there's none of that conflict, it could be a really simple process done within just a month or 2, because you open a probate case, you show the will to the judge asks if anyone objects, no objections, then everything is ordered per the terms of the will. But if there are objections, then that's where it could get complicated.
Sure, understand. Another question is the will doesn't have a trustee to execute that. So anybody can use the will and try to execute the will from the testator.
Testator?
So anybody can do it, right? Or there's no such like a trustee, people who handle it.
There is an executor. So in the will, the testator will designate an executor.
Okay, thank you.
Yeah, the executor will be the one who has the fiduciary duty to carry out the terms of the will.
Great, thanks.
Great questions. Yeah, thank you, Maurice. So going back to the estate tax exemption, the estate tax exemption is something that the government has implemented. And basically, it says that for each person, there is a specific amount that person can transfer through estate planning without being taxed. So this number changes every single year. And for the last 5-6 years, it's gone up significantly, more than double. In 2016, that number was only at $5.45 million per person. In 2021, this year, it's gone up to $11.7 million per person. That means that in 2016, each person can only transfer $5.45 million without having to pay any estate taxes. Anything above the 5.545 million was going to be taxed based on the 40% federal tax. And then if there's also state tax or inheritance tax, that's also deducted on top of it. Now it's at 11.7. So it's a lot higher. But this number is not going to be permanent. In 2022, it depends on the economy. It depends on the government. They can drop it back to 5 million anytime they want. Maybe it'll keep going up, but it could be dropped as well. So what people want to do is while it's at this amount, 11.7, they want to be able to take advantage of it. So that's why if they create a trust and they put $11.7 million into this trust and they leave the trust assets for the beneficiaries, let's say their children, that 11.7 million is locked in because it's done this year in 2021. If 2022 comes and the exemption drops back to 5 million, their 11.7 million is still estate tax free. So we want to be able to secure this higher amount before it gets reduced. If it continues going up, then great. You can always add more money into the trust and keep getting that additional estate tax exemption. But if it goes down, at least you're locked in. So that's the tax saving advantages for having estate planning done ahead of time. Any questions on the estate tax exemption? Okay, great. And also know that this is per person. So if you're married, then you get 11.7 times 2 for a couple. So you get like $23 million as an estate tax exemption. And this is only for folks that are domiciled. If someone is not domiciled in the US, the exemption is way less. It's only $60,000. So it's a big difference. If, let's say, a couple, one person is domiciled in the US and one person is not, then it's 11.7 million for the person who is, and it's 60,000 for their spouse. So that makes a huge difference whether or not there's domiciling in the US.
That's right. It makes it tricky when you want to do estate planning if you have two citizenships in the family.
Exactly.
Is it limited to the people holding the permanent residence? Some people domicile in the US, but they don't have permanent residence.
Yeah, so
tax resident, but that they won't enjoy this exemption.
Exactly. So it really makes a difference in when people are determining where to live and what to, which country to state as their official domicile, because having residency here in the US makes a big difference with disadvantage for the estate tax exemption.
Okay.
Okay, so moving on, we'll talk about the different types of trusts that you can create. There's revocable trust, there's irrevocable trust, there's living trust versus testamentary trust, funded versus unfunded. There's actually a lot of different trusts out there. There's the charitable remainder trust, there's the family dynasty trust. The list goes on and on, but I'm going to cover the most commonly used trusts that folks create. So the main one is a revocable versus an irrevocable trust. Revocable is just like how the name sounds. Revocable means that it can be changed. Once the settlor or the trustor creates it, they can make modifications anytime. And I usually recommend folks make updates to their trust once every 2 to 3 years, because usually every 2 to 3 years, there's going to be some changes to one's portfolio. Maybe some assets are sold, maybe new real estate is purchased, maybe new stocks are purchased. Things change every 2 to 3 years. So it's good to sit down with an attorney and review all your estate planning documents to make sure everything is up to date. That way, if you pass, there's no holes. And maybe some assets you just purchased that didn't get put into a trust, you don't want those assets to be going into probate. So that's the revocable trust. The irrevocable trust is something where you create it and it's set in stone. You can no longer change it later. So let's say you have a house and you know that you're not going to sell this house. You know that you're going to leave it to your children no matter what. Then you create an irrevocable trust. You set your children as your beneficiaries or whoever you want to set as your beneficiaries. But once you sign that irrevocable trust, you can't change your mind later. You can't take it out later. So a lot of people ask them, why would I want to create an irrevocable trust instead of a revocable trust if it's so much more restrictive? Well, the irrevocable trust provides a lot of advantages. One thing is that the irrevocable trust protects from creditors and lawsuits. So if you put your assets into a revocable trust and someone sues you and they know you have assets in the trust, they can actually still claim it and take it out of the trust. and put a lien on it. Whereas if you have an irrevocable trust, that asset is no longer yours. You've already designated a beneficiary that you can't change your mind on. So if that asset is no longer yours, then no matter what, if people sue you, they can't put a lien on it because it's not your asset. So that's a big advantage. On top of that, the irrevocable trust is what gives you that estate tax exemption. So you have to put an asset into an irrevocable trust in order to take advantage of the estate tax exemption. So those are the differences. And I'll give you guys an analogy so it's easier to remember the difference between revocable and irrevocable. Imagine an Amazon box. The revocable trust is an Amazon box that has not been sealed yet. You can still put items inside. You can still take items out anytime you want. It has not been taped up or mailed. It's still sitting in your house and you can make updates to it anytime. The irrevocable trust is like the Amazon box, but you put the stuff in, you seal it up, and then you mail it to your trustee. Let's say your trustee is your sister who lives in Florida. You mail the box to your sister in Florida, and she's the trustee, so she's managing it. Later on, if you change your mind and you want to add more things to your trust, it's going to be too late because that box is no longer in your possession. So you can't make any more changes to it. So that's how you can visualize the difference between a revocable trust versus an irrevocable trust. Any questions on that? Pretty straightforward?
Very straightforward to me.
Okay, awesome. Then we'll talk about how to terminate a trust. Just like how we talked about how to terminate a will earlier. To terminate a trust, you can either set a specific termination date, or you can say that upon the happening of an event, then this trust will terminate. So a lot of times the trust will say, once I pass away, then the assets will go to my beneficiaries, and then the trust will no longer be in existence. Sometimes if your beneficiaries are your children and your children are minor children and they're not ready to take over the assets yet, then you can say, upon my passing, I will create a new trust for my children, and all of these assets will go into the new trust, and this old trust will terminate so that your children can have the new trust. Same with an irrevocable trust. If you specify a termination date in the irrevocable trust, it can also terminate. And the happening of an event, it doesn't have to be upon death. See, a will only becomes effective upon death, but a trust can terminate upon the happening of anything. You can say that your children will get your assets. Let's say when they get married. If you really want your kids to get married and you don't want them to have any assets if they don't get married, you can say, when my kids get married, then they will be able to have ownership of these assets. Or you can say, when my kids have kids, so I can be a grandparent, then they will have these assets. So you can literally designate the happening of any event. You can set any condition to allow your beneficiaries to have access to the trust. So that is a big advantage. And upon that happening, the trust terminates and the assets will go to your beneficiaries. Any question on termination of a trust? Okay, if not, then we can talk about the difference between a living trust versus a testamentary trust. The living trust, everyone has heard this, living trust. That's a very commonly used term. That's probably one of the most frequently created trusts. What it means is that it's created during the settler's lifetime. It's created when the trustor is still alive. That's why it's called living trust. And when there's a living trust, the trustee is not required to file any annual accountings. So the trustee is pretty much just managing the trust. They can sign checks, they can pay bills, but they don't have to file any annual accountings. A testamentary trust, on the other hand, is something that is created with a will. So a living trust, when it's created, the assets immediately change title. So let's say you create a living trust today and you put your house into it. Then we need to change the title of the house from your name to the trust name. The testamentary trust does not change any title right now. Nothing is done while you're living. It only happens when you pass away, because it only happens when the will comes into play. So you can create a will and say, I'm not going to change the title of any of my assets right now. But when I pass, then the will is going to put all of my assets into a trust. And it's great for minor children, because then you'll have a trust where your minor children can be taken care of by the trustee. And you don't have to worry about it. And then you can say, well, my minor children turn 25 or whatever age where they can be responsible, then they can take the assets out of the trust. So that's what the testamentary trust is. It's not created until the testator passes away. All right. And then funded versus unfunded trust. Funded trust is also the more commonly done one. It means that when someone is creating the trust, they already have assets to put into the trust. So they can immediately transfer real estate. They can immediately transfer bank accounts or stocks or bonds or 401ks, anything into the trust is funded immediately. An unfunded trust is a trust that is created, but no property is put in yet. So the testamentary trust, for example, will be unfunded because no assets go in until the will puts the assets in. Some people create a trust because they are planning on purchasing a property and they're in escrow. Well, escrow has not closed yet, so they don't want to put in the property yet. But once escrow closes, then the trust is ready to go and they can put the newly purchased house straight into the unfunded trust. So that's the difference between funded versus unfunded. There's benefits to each one. Any questions on wills? All right, well, we have a few minutes left, and I also want to save some time if anyone has any questions. So we'll quickly go over powers of attorney and also dual citizenship, family estate planning, and then leave a few minutes for any questions anyone may have saved till the end. So powers of attorney is a separate document in addition to a will or a trust. What it does is it authorizes an agent, whoever the principal designates as his or her power of attorney, to act on his or her behalf in case something happens, in case they're incapacitated, in case they're in the hospital and they can't get out to sign documents. The person who has the power of attorney can basically act as them. They can sign whatever documents the principal can sign. They can execute any agreement. They can authorize any legal action. So that's the advantage of a power of attorney. There's a specific power of attorney, and there's also a general power of attorney. The general power of attorney allows that person to do anything and everything. The specific power of attorney specifies exactly what he or she can do or cannot do. So let's say you designate your sister to have specific power of attorney over this apartment building that you guys own together. Then that means your sister can only make actions on this apartment building, not on any other accounts. Or you can say this power of attorney is only for closing escrow on this property. And that way, when the escrow is done, the power of attorney is done, and they can't take that power of attorney and do anything they want with it. So when you create a power of attorney, you got to specify if it's a specific power of attorney or if it's a general power of attorney that allows them to do anything and everything. Additionally, having an advanced medical directive is also really important. What that is it's like a power of attorney, but it's for medical purposes. Some of my clients will tell me, if I'm on the hospital bed and I don't, if I have to make a choice between pulling the plug or not pulling the plug, I'm going to just have the professional make the decision. I'm going to have the doctor make the decision. Well, guess what? Doctors are not authorized to make that decision. So the doctors, what they do is they look to family members to tell them what to do. They're not going to make the decision for you. So when there is no advanced medical directive, a lot of times what happens is that family members start fighting, and it's already such a difficult time. The last thing you want is to create this challenge for your loved ones. Let's say your husband or wife knows you and knows that you don't want to be a vegetable lying in bed for the next 10 years. But let's say your mom and dad want to save you, and they're like, no matter what, even if he or she is a vegetable, we will still take care of him. We'll still feed him. We'll like dedicate the rest of our lives to take care of our child. The spouse and the parents, they're going to end up in a litigation battle, trying to figure out what is the best decision. So the best thing you can do for your loved ones is you make your decision for your own body ahead of time. And all your loved ones will have to do is follow your wishes. But when you don't make it clear, then everyone thinks they know what you want, but they're all going to be thinking differently. And it's going to create so much conflict amongst the loved ones, and it really creates a lot of rifts in the family. When something bad happens, it's supposed to bring family closer, but when there's no clarity, then it really creates a lot of conflict, and it's unnecessary if one has an advanced medical directive that just clearly states, this is what I want done if I'm in this situation. Okay. The last thing that I was asked to include in this presentation is about dual citizenship estate planning. So this happens quite often as well, because I have a lot of clients who have dual citizenship, let's say between the US and Taiwan, right? Because US and Taiwan allow dual citizenship. And a lot of clients have assets both here in the US and overseas. Like in Asia, or where they have assets in both places. So when you have dual citizenship, then you actually have extra considerations to think about. And one of the big things is tax implications. So one important rule to remember is that the US transfer taxes apply no matter where you live. If you're living in Asia, in China or in Taiwan, you might think, oh, I can transfer assets and I won't have to worry about taxes because I'm not living in the United States. Well, it doesn't matter where you live. You don't have to live in the US, and those US transfer taxes will still apply. It doesn't matter where you give the property or where you pass away, those US transfer taxes will always apply. So there's no escaping those US transfer taxes as long as you're a citizen of the United States. And then also expats, expats are the folks who have relocated to another country. They're a US citizen, but because they have dual citizenship, maybe they're living in the other country that they have citizenship in. They think that, because we are no longer residing in the US, there's not going to be an estate tax imposed on us. That is a myth. The US Treasury will still impose the estate tax, the 40% federal tax, even if you're an expat. So that's why it's so important to take advantage of that $11.7 million estate tax exemption now before it changes. I do have a PDF. It's a guide to international estate planning. So if anyone would like me to send them the PDF, it talks a lot about additional details and considerations. If you have assets not only in the US, but also internationally, I can email that guide to anybody who's interested. I will provide you with my email address right here. So if you want to send me an email here, I can provide that guide PDF version to you. And yeah, we're right at time. So I will give the spotlight back to Francine.